This video discusses a recent privacy law passed by the United Arab Emirates. The law, known as Federal Decree Law No. 45 of 2021, regarding the protection of personal data, or the PPD law, aims to bring comprehensive data protection legislation to the United Arab Emirates and, as expected, broadly mirrors the GDPR legislation. It is important to note that the PPD law will not take immediate effect and will be supplemented by the issuance of a set of executive regulations which are anticipated to be published in March 2022. Now, without further ado, let's go.
The first item that we will address is the obligations of controllers and processors under the new PPD law. Generally speaking, a controller is a person or entity that decides the purpose for processing personal data, and a processor is a person or entity that operates based on the controller's instructions, such as, for example, a cloud service operator.
In addition, under the new law, and similarly to the GDPR, controllers and processors must control the amount of personal data processed through a purpose limitation, a data minimization requirement, and a storage limitation. They must also ensure the security of personal data by maintaining appropriate technical and organizational procedures and measures appropriate to the processing risks and to industry best standards. Other important obligations include the mandate to keep personal data processing records, to maintain contractual processing agreements, and to report data breaches. The next question is, what should be done now? As with other comprehensive data privacy regulations, the first step that businesses should take is to identify the personal data currently being processed. Building the special record of personal data is not only a legal requirement, but will inform other activities required under the law. From an information governance perspective, this process may also require businesses to undertake a survey of the records that they keep. This is especially true of employment records and other types of records that may contain personal information, and to deploy defensible retention and destruction policies.
Businesses should also work with their information technology teams to determine the technical and organizational measures in place for protecting personal data. In particular, they should develop a plan to close any gaps between those measures and the express requirements under the law and national and international best standards and practices. The plan should also ensure the removal of redundant, obsolete and trivial data, also known as ROT, which comprises upwards of 70% of the data stored on an average company's servers and makes it difficult to identify and find the right records at the right time. This can lead to both internal inefficiencies and to legal liability, including potential privacy fines. Another important task is for businesses to identify their data processors and to make sure that their contracts with those processors comply with applicable law, including, for example, cross-border transfer requirements. From an information governance perspective, it is also crucial for businesses to be able to identify which contracts are the authentic, official versions. Finally, businesses should establish procedures for responding to data subject requests to exercise a right granted under the PPD law.
Our team of information governance consultants can assist businesses with many of the elements required to ensure compliance with the PPD law. Typical services, for example, can include directing businesses to software providers that target, identify and help delete ROT data, and creating and reviewing records retention policies and procedures, so as to enable businesses to deploy defensible data retention and destruction practices. Other examples include helping businesses implement usable and appropriate record-keeping procedures and provide businesses with the training that they need to comply with those policies. Contact us today.